I'm going to hopefully spend a little bit of time. It's absolutely impossible to do a healthcare fraud and abuse primer without just really hitting the tip of the iceberg type of issue spotting things for the audience here tonight. Half an hour, I can spend days literally on Stark and anti-kickback issues, and I think that Greg and Ben both would agree with me on that. So you are going to get a true 50,000 foot view of Stark and anti-kickback tonight. If we can go ahead to the next slide. Marissa's driving for me this evening. So just a little bit on who actually has police powers for healthcare fraud and abuse, because it's a lot broader than what some of you may think. There are, of course, the federal agencies like the office, the OIG, and then CMS, which of course runs the Medicare program. So you have federal agencies, you have state agencies like ACA, which oversees the state Medicaid program. The Department of Insurance occasionally gets involved if they suspect insurance fraud on commercial payers. You do have the possibility of professional boards. Under Chapter 458, there are specific bullet points for which physicians might be disciplined, and perhaps Greg and Ben have seen this in their past, where if they do see fraud and abuse issues, that could potentially turn into a licensure issue for you. Commercial payors, obviously, with overpayments and audits, prosecuting agencies like the DOJ and the state attorney, and then what I call hired guns. So bodies like CMS, ACA, sometimes they don't necessarily have all of the data and analysis experts. They hire like RACs and ZPICs to help them sift through all that data and identify people that might be of high interest in terms of fraud and abuse. All right, let's go on to the next slide. Now, how do healthcare fraud and abuse issues do they typically surface? Of course, as I mentioned just now, we have a lot of the government agencies that are pulling these are really super deep data dives. If you haven't been through one before, then that's a great thing. But we've represented physicians previously that in comparison to all of their physician colleagues within a certain medical specialty, even within a certain geographic area, their data on a specific procedure, on a specific recommendation, perhaps a specific drug may be much, much higher and way above those normal standard deviations, and they get tagged and looked at. You could be under the scrutiny of commercial payors, again, in audits. You could do self-audits. We actually have a lot of health systems and other larger clients that occasionally they just do a health audit on themselves, and they take a look at their bills and claims in connection with their billing and collections agencies, and they come up with things that may not look exactly kosher, and so they eventually end up self-reporting and or refunding overpayments to payors. And of course, last but not least, we have to always be aware of whistleblower employees. Anytime you have an employee leave you, that is, and even those that, stay on board, that is a potential whistleblower there. If they've picked up fraud and abuse issues, if they've alerted your practice as to a certain issue, you certainly want to pay attention to that, because if you haven't dug into it sufficiently and you haven't come up with whether or not you actually encountered a fraud and abuse issue, if you have to self-report, then that becomes fodder for unhappy employees that are either terminated or leave the practice. Let's go to the next slide. I'm going to have to fly through this. So what I'm going to do today is go through two basic federal statutes that Ben and Greg and I regularly deal with. The first on the federal front is the Stark Law. And you'll see that the basic points here under the Stark Law, and you'll see the cite to the actual statutory provision, is that it applies to physicians or immediate family members of physicians. We'll get to that definition in a little bit of immediate family members. Physicians who have financial relationships, and that can be through ownership or compensation, and financial relationships with who? With entities that provide certain designated healthcare services, or what we in shorthand call DHS. Next slide, please. You'll see here that this is the statutory list of DHS, really runs the gamut from everything that you might do within a physician group practice. Pretty common to do radiology services, diagnostic imaging, clinical lab, waived or not waived. If you're an ortho, you might do PT and other sort of therapy services, all the way down to look at the bottom of the list. You have things like inpatient and outpatient hospital services. Those are referrals that these physicians on our meeting might make to their partner hospitals where they have medical staff privileges. So if you have a financial relationship with a hospital, ownership, compensation, or otherwise, you probably have to watch out for Stark. Next slide. Okay, so I get asked a lot, do I actually have a financial relationship under the Stark Law? And that is an incredibly complex question. So what you really need to do is to get somebody to analyze that for you, because these financial relationships are defined, they can be direct. Direct financial compensation arrangement, for example, is, if I'm a hospital and I pay a physician for a medical directorship, I literally cut a check to them. That's obviously direct. Indirect compensation arrangement, if I have a health system and they have an arrangement with a physician group practice, and then the group practice in turn pays a specific physician, that's an indirect compensation arrangement. Same sort of thing with direct and indirect ownership. Any one of those, so you have really, 4 different permutations of financial relationships. And then you have some really complex exceptions under the financial relationship definition. We're not going to go through all of those tonight. Just know that it can be, pretty into the weeds there. And then also don't forget that a financial relationship really can be triggered if you have an immediate family member that has a financial relationship with a DHS entity. And you'll see there a really broad overall definition of what might be immediate family, spouse, parents, children, siblings, and most step relationships. Let's go ahead, next slide. And, here I am scaring all of you that are online with us tonight. These are the sanctions under Stark: denial of payment, necessity of refunding claims that were billed in violation of the law. You have CMPs, or civil monetary penalties, for services that were billed in violation of the law. This is also very important, that 4th bullet. The CMP law, civil monetary penalties law, is actually a completely separate fraud and abuse statute under federal law. No time to review all of that tonight, but know that to the extent you bill claims in violation of Stark or even anti-kickback that we'll go through in a minute, the government can come after you for treble, what we call treble damages, or 3 times the amount of the claims that you billed. How that usually works out is if you end up in a position where you're negotiating an overpayment, or you're negotiating with DOJ, they'll typically start out with treble. Oftentimes they'll reduce to the extent that you have like self-reported or you've otherwise been a good citizen. But that is a possibility of getting treble damages. It's not just a simple refund. Additional CMPs for circumvention schemes. And of course, ultimately, what we all don't want to happen is exclusion for government healthcare programs. Next slide. All right, so now that I've scared you enough, just realize that there's also a lot of commonly relied upon Stark Law exceptions that are in the statute. Again, no time to go through all the nitty-gritty of what you need to do in order to meet a Stark Law exception. Just know that number one, Stark is basically you either meet it or you don't in terms of an exception. If you don't, then that potentially poses a regulatory and compliance issue for you. But these are some of for physicians, these are some of the more commonly relied upon exceptions that I've cited here. You can have a contract for rental of space and equipment. I'm hitting that in the middle of the list there. You can be a bona fide employee of a physician group practice, a health system, or another DHS entity. You could have a personal services arrangement. That could also be your employment agreement. It could be an independent contractor agreement. It could be some sort of medical directorship. We have a lot of physicians that have research arrangements. So you want to take a look at whether or not that meets all of the regulatory requirements. In-office ancillary service, if you are in a physician group practice and you have lab, radiology, if you do radiation oncology as part of your practice overall. These are services that are, going to be overseen by either a physician or somebody that is supervised by a physician in your practice. A lot of technicalities as to where you can perform it, how it needs to be billed, how it needs to be structured within a group practice, how you share profits and expenses and losses as to all those in-office ancillary services. So there's a lot of structure to IOAS and that exception. Of course, if you personally perform a service, that is accepted under Stark. If you supervise somebody like a PA or an NP that personally performs a service, that could be accepted under Stark. A lot of our area health systems provide practitioner recruitment to the extent that they need to fulfill a clinical specialty need. Those are a beast unto themselves. They are very specially highly regulated in terms of what a health system can provide, how much, for how long, to subsidize bringing on a physician from outside of the hospital's area to inside the hospital's area. And then finally, something that we work on occasion are isolated transactions. If you are selling your practice to a health system, but yet you are also remaining on board on the medical staff and you still might make referrals, that's going to involve some money paid by the health system to you, obviously. We want to make sure that that is not going to be for the referrals themselves. So there are very special rules on isolated transactions. Those are the most often used. I've put in caps here the golden rule, and that is that a lot of these exceptions rely upon a few key points, and that is they have to be fair market value. You're going to probably encounter some third-party accounting firms, valuation firms that are engaged if you're working with a hospital or health system that can help determine fair market value. It's not just what the parties believe is fair market, not just what they negotiated as amongst themselves. There are actual studies out there on fair market. Must be commercially reasonable. So does the relationship make sense? Or is it something that would not typically be entered into by two parties? And it should not be key to the volume or value of referrals or business generated as between the parties. All right, next slide. Federal anti-kickback law, same but very, very different. What it says here is that if you knowingly or willfully offer, pay, solicit, receive any sort of payment, any sort of compensation or remuneration. It could be direct, indirect. It could be overt or covert, so under the table or not. It could be in cash. It could be in kind. So you could get free stuff in exchange for referrals, and that is a problem. For any item or service, so not just DHS, and purchasing or leasing or ordering or arranging for any good or facility. Again, not just DHS. This is a criminal statute, whereas Stark is a civil statute, and you can see the penalties for violations under federal anti-kickback law. Let's bring up the next slide just really briefly. I think it will help. I can't credit myself for this chart. This actually comes straight off of the government's website. You can see the differences between anti-kickback on the left and then the Stark law on the right-hand column. You can see that the referrals under anti-kickback can really be from anyone. It doesn't have to be, it could be from a pharmaceutical company, it could be from a physician to each other. And then with the Stark law, however, again, you're dealing with physicians. Okay, items and services, we just went through that super briefly. Stark law, DHS, there's a list. For anti-kickback, it's any healthcare items or services. Intent, because anti-kickback statute is a criminal statute, it has to be knowing and willful, what we call mens rea under criminal law. And under Stark, it's strict liability. You either violate it or you don't violate it. And if you violate it, it's a problem. If you don't, if you violate it, no amount of saying, but I didn't know, or I didn't mean it, will ever help you under Stark. And of course, we go through the civil and criminal penalties under the two statutes there. Let's flip to the next slide. Okay, so just like in Stark law, there's a lot of safe harbors. We call them safe harbors for federal anti-kickback purposes. I've listed them here. I'm not going to go through all of them. Some of them read actually, for example, leases, personal services agreements. Those read very much like what you might see under Stark, but beware, because they're not exactly the same. There are a few nuances here and there, but just understand that to the extent that you have a Stark law exception, a lot of times you might have a comparable federal anti-kickback exception. Next slide, please. Okay, we could probably go to the next one, actually, just in the interest of time. Okay, Stark does this too. CMS issues advisory opinions, not quite as robust as the OIG for federal anti-kickback law. I've actually given you the link here. They're pretty interesting. The OIG is really, really active in terms of people seeking advisory opinions from them, probably because the law is just a little bit broader, and of course it's criminal, so people are probably a little bit more sensitized as to the violations there. You can pull up every single opinion historically, advisory opinion that the OIG has ever done on that link that is here on this slide. Basically, what happens there is parties submit their facts of their specific situation, and any relevant documents. The OIG has the right to ask for, additional facts and information. And then what happens is the OIG at the end of the day will come up with one of three scenarios. Number one, this is a clear violation of federal anti-kickback law. You can't do it. It's a super bad thing. Don't do it. Number two, you're in the clear. You do not violate the federal anti-kickback law. Those two we see relatively fewer of. What we see a whole lot of is number three. This could potentially violate the federal anti-kickback law, but we will choose not to prosecute it under the law for now due to, and then they'll list a number of specific factors for this specific requester or requestors in the advisory opinion, the AO, because they may feel that the risk to the federal agency is a little bit insulated because this, that, or the other. The thing to remember here is you can pull all the advisory opinions you want, but it really only blesses the parties that sought that advisory opinion. So you could read an advisory opinion and say, but I have a contract or I have a financial relationship that's exactly the same as advisory opinion XXOO. However, you can't rely upon it 100%. It really only blesses the parties that sought the opinion. What the rest of us do is we do read it for personal edification. We try to structure it so that if it ever does come up, we can say, but the government said it was okay here. Again, the OIG actually maintains a lot of leverage and flexibility in deciding whether or not an issue is a set of facts is truly an issue under federal anti-kickback law. Let's go to the next slide. I get a lot of these questions, top three questions that I'm typically asked when I'm dealing with a newer client who is fresh to the federal anti-kickback law. First is my failure to meet 100% of the requirements under a federal anti-kickback safe harbor, does that mean that I've actually violated the law? And the answer to that is no. The OIG will say, you can meet 99.9%, you don't meet 100%, but what we do is it's a facts and circumstances test for us. So we get to go in and say, okay, you've met most of it, and because of a lot of, again, insulating conditions, we're not going to be consider what you are doing a violation of the law. That's what they typically do, again, in the advisory opinion process. Second question that I get, if I do meet 100% of the requirements under a safe harbor, I'm safe, right? I'm home free. I don't ever have to worry about the government breathing down my neck. That is absolutely incorrect. I'm sure that Greg and Ben can agree with that we've all had situations where the government will come in and it will say, despite the fact that you may have had a rock solid contract for a medical directorship, and it was paid pursuant to, you met all of the indicia of a personal services arrangement. We're going behind that because we believe that maybe the intent of the parties was not there. So for example, there was a rash of cases a little while back where there were, research contracts or medical directorship contracts. Physicians were required to sort of record what they were doing. In these particular cases, what the government found was there really was nothing done in exchange for the compensation that was paid. Sometimes the timesheets were false. Sometimes the timesheets were just, filled out at the end of the month. And regardless of whatever time was actually placed on the timesheet, the physician was paid, sort of maximum amount. So in that case, the federal government goes behind and says, you may think that you met all the indicia of the safe harbor, but the intent of the parties was not right. And so we're going behind that. Last but not least is that, constant confusion over, well, if I'm okay under Stark, I'm okay under federal anti-kickback. Is that right? Not necessarily. Again, they are two different laws, and there are some nuances as to those safe harbors and exceptions. You'll also find that in federal anti-kickback, the golden rule still applies. Fair market value, commercially reasonable, not keyed to volume or value of referrals. Can't do that. Okay, next slide. I think what we're going to do now is buzz through the state statutes in interest of time. So what you need to know is that we call these baby Stark, baby anti-kickback. There are state law counterparts to Stark and federal anti-kickback laws. You'll see here the Florida statute 456-053. That's the Florida Patient Self-Referral Act, or what I call baby Stark. So this is quoted, you start off with a prohibition under subsection 5. You basically cannot, a healthcare provider cannot refer a patient for the provision of, again, here we have the concept of DHS to an entity in which the healthcare provider is an investor or have an investment interest. And then there's a sub B, cannot refer for any other healthcare item or services to an entity in which the healthcare provider is an investor unless certain requirements are met. So you start out with a general prohibition, and let's go to some of those exceptions that may apply. You'll find on the next slide, please.
I'm still here, Charmaine. It's giving me a message. 1 minute. It's just trying to connect.
That's okay.
The night of technical difficulties. Apologize.
That's okay. I get to rest a little bit my voice after going a mile a minute. Okay, I'll just keep on talking if that's okay with everybody so that we save Ben's time. I will say that there is actually a definition, if I'm looking to the other screen, it's because I'm reading the slides on my personal computer. So there is a definition of referral in the Baby Stark Law. And really, to the extent that you're forwarding a patient to another healthcare provider, or you're requesting an establishment of a plan of care, that is establishing a potential referral relationship, right? So you need to watch out to the extent that you have an ownership arrangement or investment interest in an entity, and you're making any sort of referral. So even establishing a plan of care could potentially be a referral. You saw that definition reference for designated health services. Again, it is a much smaller list under state law: clinical lab, PT, comprehensive rehab, any sort of diagnostic imaging, and then radiation therapy. So if you're not in that DHS list, you probably don't have to worry about the Baby Stark Law. Now, in terms of exceptions, the Baby Stark Law in Florida actually has very clinically specific exceptions. So there is a long list of things that are not considered referrals under Baby Stark Law in Florida. So for example, radiologists for diagnostic imaging services, cancer specialists for radiation therapy, medical oncologists for drugs. You have a whole long list of specific clinical, there we go. And I think that we're about 2 slides down, Marissa. Thank you so much. There we go. Okay, we can probably flip to the next one, actually. Yeah. cardiologist for cardiac cath. So the one that most of you probably want to pay attention to, if you're in a medical specialty that isn't sort of specifically listed, is the big long one in F. That is the one for solo practitioners or group practices. To the extent that you are providing a DHS services solely for your group's own patients, and then under your supervision directly or under the supervision of somebody else in your group practice, then that is considered sort of the group practice exception under the Florida Patient Self-Referral Act. That is a huge exception that we always rely upon for a lot of our large physician practices. Okay, I think we can go to the next one. Oh, those are more clinically specific. Let's go and flip on to the next slide. All right, so now we deal with the Florida Physician Anti-Kickback Law. This is the statute immediately after the Florida Physician Self-Referral Act. You'll see that title of the law, kickbacks are prohibited. So here a kickback just again means any sort of payment that is going to another person in exchange for the referral that relate to healthcare items or services, present or future. And this is interesting, not tax deductible as an ordinary or necessary expense. So to the extent that you have you're paying an employee, you're paying an independent contractor, you might be able to deduct that as an ordinary and necessary expense, perhaps not quite as an issue under the Florida Physician Anti-Kickback Law. You should note that there's also anti-kickback provisions that apply to specific healthcare entities like dialysis clinics, clinical labs. These are, again, federal anti-kickback is punishable as a federal crime. Florida anti-kickback as its counterpart, punishable as a state criminal offense, and there's a separate statute for that. Okay, I think I have one more slide if I'm not mistaken. I did want to just do a quick mention on how best to remain compliant. I would strongly encourage you guys to click on that link in the second bullet. That is the OIG's compliance program guidance for individuals, physicians, and small group physician practices. It's a bit of a long read. So, if you are winding down at night and you need something interesting to read before bed, pick it up. I have sort of highlighted here a few of the key points that the OIG says helps to encourage compliance within a physician group practice construct, certainly to the extent that you are doing those internal audits. I mentioned those closer to the top of our lecture. If you are self-auditing, using your billing company to maybe, take a look at what's going out in terms of bills every once in a while, that is a good practice. If you've actually adopted compliance and practice standards and policies, that is a good practice. If you've designated somebody as your compliance officer, that is a good practice. If you've trained and you've educated your staff on how to identify fraud, waste, abuse, and who to go to in terms of the compliance officer or otherwise to report either, on a anonymous basis or, sort of a face-to-face basis that they have concerns about something that's going on within the practice. That is a good practice. So open lines of communication, again, doing corrective actions. And what the government means by that is if you find that you have, misapplied some payments, if you've misbilled some things, and if you return it and you correct that, they look to that. So we talked a little bit further up in our lecture about those treble damages. These are all sort of conditions that the government takes a look at to see whether or not you've done them. And if you have, and if you are generally sort of trying to be a good citizen, that can help. Not always, but most of the time it can help to ratchet down those potential penalties. All right, so questions, answers, tried to keep you back on time generally. Certainly happy to be here, and to the extent you guys have questions that you think about afterwards, you can email any of us.
You just have a comment.
Yeah.
Yeah, actually, Charmaine's lecture is literally priceless, only because I've been on the inside of institutions and I've seen how it affects hospital systems. And what she's talking about, the AKS, the False Claims Act, all of these sorts of regulatory schemes that we have to comply by, it's absolutely a must. It's absolutely priceless. If somebody gets dinged with it as an institution, it means a whole lot of slowing down of the business, slowing down of what their strategy is. So talking to somebody like Charmaine is literally, it'd be like one of my top things that I would do as a physician if I was looking to start up a new line of business or something.
Thanks for that. That's quite kind of you, seeing that you're also equally as expert in all of this as I am.